Hello and welcome to today's webinar on getting to grips with data protection and the EU General Data Protection Regulation. My name is Mike Hibberd and with me today is Louise Merrell. Today we'll be looking at the upcoming regulation and the impact the changes are going to have on organisations. We'll be summarising the current law under the Data Protection Act in a number of key areas and how the law is set to change under the regulation. We will then also be considering the practical implication of these changes and the steps your organisations should be considering. So in this webinar, we will first give you a brief outline of the regulation. We'll look at the rationale behind the changes that are coming in, and then in the main part of the webinar, Louise and I will explore the key changes incoming and the potential impact these will have on your organisations. Finally, we will set out our recommendations of the key steps you should be taking now to prepare. So what is the new regulation? The current data protection framework in the UK is governed by the Data Protection Act 1998. Despite the increasing transnational flow of data in companies, each member state of the EU has their own set of data protection laws. Over time, the Data Protection Act has become outdated and struggled to keep up with the ever-accelerating changes in technology. The new regulation seeks to address this. The regulation will provide a uniform set of rules for member states. However, member states may make more specific rules in certain areas, including employment. The new regulation is bringing in a whole range of changes which businesses need to be considering now. Today we will look at these key changes and what you should be doing to ensure you are able to comply when the regulation takes effect. The key date for the regulation coming in force is the 25th of May next year. Now, Brexit has not affected the incoming regulation. In November 2016, the government confirmed that the UK will be adopting the regulation. The latest news is that legislation will also be enacted to repeal parts of the Data Protection Act to ensure it is not inconsistent with the regulation when it comes in. Furthermore, the Queen's speech in June confirmed that a new law is being introduced to ensure that the United Kingdom retains its world-class regime for protecting personal data through the new legislation. Furthermore, as we will explore today, one of the provisions of the regulation is that for cross-border transfers of data, personal data may only be transferred outside of the EU, which will include the UK once it leaves following Brexit, in compliance with the conditions for transfer set out in the regulation. Therefore, in practice, the UK's legal framework, even after Brexit, will need to ensure it meets the requirements of the regulation. It is worth just taking a quick minute to see why this is important. Data protection and the implications when something goes wrong is never far from the front pages of the media. Consider the recent WannaCry ransomware attacks on organisations such as the NHS, the Petra ransomware attacks which hit parts of Europe at the end of June. Data system vulnerabilities can cripple a business and lead to very negative press. In addition, as Louise will explain, the possible sanctions for not complying with data protection obligations are set to rise. Data protection is simply something businesses cannot afford to ignore.
The current maximum monetary penalties for data protection breaches differ across the EU, with the UK being able to impose up to £500,000. Under the regulation, the penalty will increase for most offences to up to €20 million, or 4% of an organisation's annual worldwide turnover, whichever is higher. It's worth noting that there are some breaches that will attract a slightly lower penalty of up to €10 million, or 2% of annual worldwide turnover, such as violations relating to internal record keeping. Given the higher penalty, businesses will need to reassess the risks that they may face here. It would be wise for businesses to carry out information audits to assess what personal data is collected, what it's used for, who has access to this, where it's transferred, and any security measures that may be required. However, in practice, the UK may not actually see higher penalties being awarded. The Information Commissioner's Office, or the ICO for short, is the body which regulates data protection in the UK, and it has a reputation for adopting a pragmatic approach. Despite having the ability to award up to £500,000 since 2010, the largest penalty it has issued has been for £400,000. This penalty has been issued twice, firstly against TalkTalk in 2016 in relation to the cyber attack on its systems, and secondly against Kaboom Communications Limited in 2017 in respect of 99.5 million nuisance calls. This being said, we have seen large penalties being made by the ICO in the last 6 months. In addition to the £400,000 penalty against Kaboom, we've seen a £270,000 penalty against Road Accident Consult Limited, trading as Media Tactics, a £150,000 penalty against Basildon Borough Council, and a £150,000 penalty against the Greater Manchester Police. Bearing in mind the ICO has been accused of lacking teeth, it may well want to make some firm examples of companies in breach of data protection legislation next year.
A further key change coming in is that obligations under the regulation will fall on data processors. The current position under the Data Protection Act is that only data controllers have obligations under the Act. A data processor is someone who processes data on behalf of the data controller. A common example is external payroll providers. In contrast, a data controller determines how the data is processed and controls the use of the personal data. So the data controller provides the instructions to the data processors on how the data is to be used. So, as we mentioned, the current position is that only data controllers are liable. By way of an example, in 2012, the Brighton and Sussex University Hospitals NHS Trust was fined £325,000 when a company it engaged to destroy hard drives failed to do so and instead sold them on eBay. Here, the wrongdoing is clearly on behalf of the data processor as they did not carry out the instructions. However, the fine from the ICO fell on the data controller, namely the NHS Trust. Under the new regulation, this is set to change and data processors can also be held liable. A processor will be liable where it breaches the regulation or acts contrary to the instructions of the data controller. Where both parties are at fault for any wrongdoing, the regulation sets out that each will be liable for the entire damage to ensure that the compensation is paid, and then the paying party will have the ability to pursue the non-paying party for their part of the compensation. The regulation also gives the right to data controllers to audit their processors to ensure that they are data protection compliant. A further key change is that data protection agreements must be in writing. So the potential impact of this is that there are likely to be more debates between data controllers and data processors over liability for any breaches. Both data controllers and data processors should ensure their commercial contracts adequately cover the apportionment of liability. There may also be increased costs for the services of data processors if they're going to have to bear the burden of any wrongdoing on their part. So in your commercial contracts, you need to think if there is a provision for data protection breaches at the moment. In addition, you may want to have a clause for data protection breach notifications to the other party. When reviewing your existing contracts and approaching the other side for any amendments in line with the regulation, this may be an opportunity to insert indemnities or to amend your indemnities to cover your losses if the other party fails to comply with the obligations both under the contract and the regulation. We are expecting some further guidance from the ICO this year on contracts and liability.
Now let's turn to the issue of consent. Currently, data will only be processed fairly if one of the conditions specified in Schedule 2 of the Data Protection Act is met, and for sensitive personal data, one of the conditions set out in Schedule 3 of the Act must also be met. One of the conditions in Schedule 2 is that the data subject has given his consent to the processing, and Schedule 3 also refers to consent but adds that it must be explicit. There's no formal definition of consent in the Data Protection Act. Under the regulation, it remains the case that data can be processed with an individual's consent. However, the regulation is stricter on what amounts to consent, making it more difficult to obtain. The definition of consent in the regulation makes clear that it must be freely given, specific, informed, and unambiguous. An agreement must be signified by a statement or by clear affirmative action. Again, consent needs to be explicit for sensitive data. Silence, pre-ticked boxes, or inactivity will not be sufficient. Consent will not be freely given if an individual has no genuine choice and is unable to refuse or withdraw consent without detriment. The individual must be notified of their rights to withdraw their consent, and they must be able to withdraw their consent at any time. It must be as easy to withdraw consent as it is to give it. The onus is on the company to demonstrate that consent has been given, and finally, where consent is given as part of a written document which also contains other matters, it must be clearly distinguishable from the other matters. When the processing has multiple purposes, the data subject should be given their consent to each of the processing purposes. It will not be binding otherwise. At the moment, it's common for consent to be sought via pre-ticked boxes, in privacy policies, or within wider contractual terms. Employers, in particular, often obtain consent to data processing via standard clauses in the contract of employment. Under the regulation, consent obtained by such means is in danger of being invalid. Organisations and employers will need to ensure that requests for consent are clear, and if contained in a wider agreement, such as an employment contract, they must be clearly distinguishable. It would perhaps be simpler to have them in a separate document altogether. There's also an argument, particularly with employees, that at the start of a relationship they're in an unequal bargaining position, and therefore requesting consent as part of the initial contract terms may call into question whether their consent has been freely given. This is another reason why a separate consent form might be preferable. Organisations and employers will need to ensure that individuals are made aware of their right to withdraw consent and that there's measures in place to adequately record compliance. Whilst it's not automatically required for companies to refresh all existing consents given previously under the Data Protection Act, these consents may not be valid post-May 2018 if they're not compliant with the new regulation, and so companies may want to assess now how best it is to tackle this with their workforce. Finally, it should be remembered that there are other lawful reasons for processing data, and consent's not always required. For example, personal data may still be processed if it's necessary for the purposes of the legitimate interests pursued by the controller or by a third party, and where such interests don't prejudice the interests or fundamental rights of the data subject. This legitimate interest point is contained in both the Data Protection Act and the regulation, albeit in slightly different forms.
Another area in which we are seeing key changes is in data access requests. We will be dealing in detail with data access requests in our next seminar in September. However, we will briefly touch on the changes being made today. As many organisations are aware, data access requests are becoming an ever-increased tool for disgruntled individuals to bring claims or cause a nuisance to the business. The current position is that data controllers have 40 days to deal with subject access requests. In this 40-day period, they need to locate and provide, in an intelligible form, a copy of all the personal data they hold on an individual. In the days of email and numerous correspondence, clearly there's a huge administrative burden on data controllers to comply, and the 40-day time limit is not long for this to be dealt with. Data controllers may also charge a fee, but this is only for £10, so they have 40 days from receiving the request to obtain all of the relevant information, and they get £10 for this. Under the new regulation, requests will need to be complied with without undue delay, and within 1 month, although there will be an extension available for a further 2 months when necessary to take into account the complexity of the request and number of requests. This extension recognises the complexities inherent in modern technology-dependent workplaces and will mean that in many cases employers and data controllers may have up to 3 months to comply, although we will need further guidance from the ICO in due course. In complying with the request, individuals will have the right to more information, such as details of the period of time for which the data is to be stored, information about the existence of the rights to erasure, to rectification, to restriction of processing, to object to the processing, and the right to complain to the ICO. This final additional requirement is significant. If you're dealing with a disgruntled individual who brings the data access request because they want to cause a nuisance, you need to make sure that your organisation is complying with the request, because you set out in writing, in the response, what they can do if they're dissatisfied. And if they bring a complaint to the ICO will want to see that you've taken your data protection obligations seriously. In addition, data controllers will no longer be able to charge a £10 fee for compliance. However, they may be able to refuse to comply or charge a reasonable fee based on administrative costs where the request is deemed manifestly unfounded or excessive. The regulation wording says this will be the case in particular because of the repetitive character of a request, but does not limit it to this. The onus will be on the data controller to show that the request is manifestly unfounded or excessive, and in practice it does not give a blanket refusal for organisations to comply. It may be that onerous requests which produce thousands of results and days of work may be caught, but at this stage, without further guidance from the ICO, it is unclear. If organisations refuse to comply on the above basis, namely that it's manifestly unfounded or excessive, they must explain their reasons for this to the individual and inform them of their right to complain to the ICO and to a judicial remedy without undue delay, and at the latest within 1 month. There's no exemption for onerous requests. However, if you process large amounts of information, you may be able to ask the individual to specify the information or processing that the request relates to. So in terms of practical steps you should be taking now, you need to ensure that you'll be able to comply with straightforward requests in the 1 month time frame. The ICO guidance on the upcoming regulation also suggests considering any financial or other implications of having to deal with requests more quickly, especially where a large number of requests are handled by an organisation. It may be worth considering whether it is desirable to have systems in place to allow individuals to access their information more easily online. Organisations should consider amending their policies now to make it clear when requests are likely to be seen as manifestly unfounded or excessive, so both parties know at the start of the request what they deem that provision to be, and it shows the ICO that you have taken the consideration seriously.
There are other changes to data subject rights worth highlighting here. At present, data subjects have rights including the right of access, the right to restrict processing where it causes damage or distress, and the right to information, such as the right to be told who the data controller is, the purpose for processing, and any further information necessary in the circumstances. Under the Data Protection Act, there are also rights to have data rectified, blocked, erased, or destroyed via an application to the court. The regulation reaffirms and expands on the rights data subjects have, and also creates a few new ones. Let's look at a few of these. The right to information has been expanded and includes, for example, the right to know the legal basis for processing, any legitimate interests, data retention periods, and the right to lodge a complaint to the ICO. If data is collected from the data subject, this information should be provided at the time the data is collected. Otherwise, generally speaking, it should be provided without undue delay and within 1 month of receipt. There's a right of erasure, commonly referred to in the press as the right to be forgotten. The regulation will give data subjects the right to have their personal data erased without undue delay where certain conditions are satisfied. For example, where the personal data is no longer necessary in relation to the purposes for which it was collected, or the individual withdraws their consent on which the processing was based, and there's no other legal ground for the processing. Again, this should be done within 1 month of the request, although it can be extended in these circumstances to 3 months. If the information has been shared, the data controller or processor should notify those who have received it unless this would cause disproportionate effort. There are some circumstances where this right will not apply. For example, the exercise of freedom of expression, or to comply with a legal obligation, or where it's for the defence of legal claims. Now, this right was no doubt influenced by the case in May 2014 against Google, which received much press attention at the time. There's also a new right to data portability. This gives data subjects the right to receive data which they have provided to the controller in a structured, commonly used machine-readable form, so that their data can be transferred without hindrance from one IT environment to another in a safe and secure way. This must be provided within 1 month of the request, although again it can be extended to 3 months. There's a right to rectification and a right to restrict processing in certain circumstances. There's also a right to object with specific reference to direct marketing. Again, this should be dealt with within 1 month of the request, with a possible extension to 3 months. If the information has been shared, the data controller or processor should notify the recipients unless this would involve disproportionate effort. Now, in practice, it's unclear at this stage how all of this will work. The new data portability right may seem daunting, but as it only applies to information supplied by the data subject themselves, and not, for example, all their personal data like in an access request, organisations just need to ensure they have a way of recording information received from the data subject and that it's kept in a readily accessible form. Businesses will need to consider their administrative processes and technical resources to ensure they can adequately address individuals' concerns and rights, and they'll need to provide training to those within the business who may be faced with requests or complaints on personal data, or at least ensure they know who to speak with. Privacy notices will need amending so that they include all the new information, including the basis for processing, data retention periods, and that the individual can complain to the ICO if they think there are issues in the way an organisation has handled their data. This should be provided in a concise and easy to understand language.
A further key change brought by the regulation is the right of notification. Under the Data Protection Act, some organisations do have a duty to report, but there is no blanket legal obligation across the board to report data protection breaches. The ICO believe that breaches of security resulting in loss, release or corruption of personal data should be notified to it, and in such circumstances it may help when dealing with any liability and remedy, but there is nothing enshrined in law. The ICO guidance also suggested that if there was little risk to individual, notification currently is not needed. For example, if a laptop went missing but all of the personal data on there was encrypted. However, under the regulation, the ICO's current preference for notification is put into statute. There is a mandatory reporting requirement of all breaches to the ICO and to data subjects themselves. Any such notification needs to be made without undue delay and, where feasible, within 72 hours of the breach, unless it is unlikely to result in a risk to the rights and freedoms of data subjects. If an organisation makes a notification outside of this 72-hour window, they will need to provide their reasons for the delay to the ICO, essentially already putting them on the back foot. In addition, there is a requirement to, without undue delay, report to the individual if the breach is likely to be a high risk to their rights and freedom. This may not apply where measures have been taken to limit the risk, such as encryption. The ICO guidance suggests that the notification obligations will be assessed on a case-by-case basis. However, it's worth mentioning now that a failure to notify could attract a fine of up to €10 million or 2% of a global turnover of an organisation. This is in addition to the fine from the breach in the first place. Suddenly, data protection obligations and breaches are getting more and more costly, and therefore policies need to be considered now in how they are going to respond to any possible data protection breaches. So the steps your organisation should be taking now is to make staff aware of what constitutes a breach and ensure there are internal processes in place to deal and report. Any breaches need to be addressed promptly, so training is crucial. Organisations should consider implementing a data response plan. It will need to include training, designating specific roles within an organisation and what the responsibilities for each of these roles will be. Organisations may also wish to prepare a notification template now to be used when a breach occurs, so it is easier to deal with any breach and the notification within the 72 hours window. Organisations should also include procedures to detect, report and investigate personal data breaches. Finally, as part of these policies, organisations should have procedures to be able to comply with the requests by individuals to erase, transfer or restrict the processing of their external data.
There's a notable shift in the regulation towards accountability and risk assessment. Currently, there are no provisions in the Data Protection Act requiring a data controller to demonstrate compliance with its obligations, nor are there mandatory risk assessments required as a precursor to processing data. However, the regulation encourages risk assessments for the processing of personal data and greater accountability for businesses in complying with their obligations. Looking at risk assessments, the regulation requires a mandatory risk assessment to be carried out if new technology or processing is likely to result in a high risk to the rights and freedoms of the data subject. If there's a high risk, organisations will also have a duty to consult with the ICO prior to processing. In terms of accountability, the regulation requires the data controller or processor to be responsible for and able to demonstrate compliance with its legal obligations. The onus is also on the data controller and processor for many parts of the data protection regime, including evidencing consent or where it's asserted that a data access request is manifestly unfounded or excessive. So in terms of the practical steps to take now, for risk assessments, the first step is for businesses to identify whether any of its activities fall into the high-risk categories in the regulation. If so, it will need to determine who will undertake the impact assessment and how the process will work. Businesses should consider whether changes are needed to compliance strategies and will need to ensure measures are in place for adequate reporting to the ICO. The regulation gives broad categories of high-risk activities. Essentially, these are when there's systematic and extensive evaluation of personal data based on automated processing, including profiling, which produces significant effects for the individual. Where there's processing on a large scale of special categories of data or data relating to criminal convictions and offences, or where there's large-scale systematic monitoring of a public area. A working party has been created comprised of representatives from the regulatory bodies of the member states. It's known as the Article 29 Working Party, and it provides guidance on the regulation, including useful practical examples, questionnaires and FAQs. This working party has produced draft guidance on how to determine if processing is likely to result in a high risk. The link to this can be seen later in our slides. However, some practical examples of high-risk activities include a hospital that keeps patients' medical records, a private investigator keeping offenders' details, a bank that screens its customers against a credit reference database, or a company building behavioural or marketing profiles based on usage or navigation of its website. It could also apply to tools used in recruitment, such as automated recruitment decisions. In terms of its accountability, businesses need to ensure that they have processes in place to demonstrate compliance. Internal training may be needed, particularly around the lawful basis for processing personal data and how to document this. Under the regulation, low-risk processing activities may face a reduced compliance burden.
Another change under the new regulation is the need in some circumstances to appoint a data protection officer. Under the Data Protection Act, the current law does not pose any such obligation. However, with the regulation, it will be mandatory to appoint a data protection officer in certain circumstances, namely if your organisation is a public authority, except for courts acting in their judicial capacity, carries out large-scale systematic monitoring of individuals, for example online behaviour tracking, or carries out large-scale processing of special categories of data such as race, ethnic origin, genetic data and political belief. This is similar to the categories of personal data known as sensitive personal data under the Data Protection Act, which we addressed in our previous webinar. In addition, it will be mandatory if the organisation carries out large-scale processing of data relating to criminal convictions or offences. The Data Protection Officer has minimum specified duties in the regulation. These include the duty to inform, advise, be a point of contact for data subjects, monitor compliance within the organisation, and there are specific obligations placed on the business too, to provide support and resources to the officer. The Data Protection Officer must report into the highest level of management. In addition, the Data Protection Officer has the right under the regulation to not be subjected to any detriment through carrying out his role. With group structures, it is possible to have one Data Protection Officer for the whole group, and public authorities may also have one between them depending on their structure and their size. While there is no requirement under the regulation for the officer to have qualifications, they will need to have a knowledge of data protection law. So businesses should now be considering if they need to formally appoint or would benefit anyway from appointing a data protection officer. Then they have someone within the organisation who is responsible for data protection and compliance. Whether a data protection officer is to be introduced or not, measures such as training need to be considered.
The final change we want to highlight is the change to territorial scope of data protection legislation. Currently, companies established in the EU are covered. Further, those outside of the EU will be covered provided they use equipment in the UK for processing data other than for transit through the UK. Under the regulation, as before, those established within the EU will be caught. However, potentially more non-EU controllers and processors will be subject to the regulation, and this will of course include the UK when it leaves the EU. Non-EU companies will be caught if they either offer goods and services to data subjects in the EU, irrespective of whether payment is received, or they monitor data subjects' behaviour insofar as that behaviour takes place within the EU. Businesses established outside the EU should consider whether they are subject to the regulation, and if so, these businesses should seek advice on their compliance obligations. Organisations which operate across EU member states may appoint a lead supervisory authority so that they're not having to deal with several regulators. The lead supervisory authority will take the lead in investigations with input as required from the other relevant authorities. Broadly speaking, the lead authority will be the one operating in the area where the data controller or processor has their main establishment. The main establishment will be the place of its central administration, unless decisions on the purposes and means of processing are taken in a different establishment, in which case that one will be regarded as the main establishment. Businesses operating across the EU should consider who their lead authority will be. So by way of example, a retailer has headquarters in London but has establishments in other EU countries. All establishments use the same software to process consumer information for marketing purposes. All decisions about the processes are made in London. The company's lead supervisory authority will be England's supervisory authority, i.e. the ICO. Taking another example, a bank has headquarters in London and makes all decisions re the banking activities there. However, its insurance department is located in Vienna, and the establishment in Vienna has the power to decide all insurance processing for the EU. Here, the Austrian supervisory authority would be the lead in relation to the processing of the insurance data, and England's authority would be the lead for the banking data.
As we have tried to set out to you throughout this webinar, there are a series of steps your organisation needs to be considering now. On this slide, we have highlighted what we think are the key steps to be taking now. The priorities are to consider your data protection systems. Are they up to date? Is your data secure? Do you have safeguards in place such as encryptions? And do you need to carry out now an information audit to highlight any shortcomings in your data protection systems? Secondly, you should be reviewing the bases on which you process data. Do you currently solely rely on consent? If so, is this consent going to be valid or does it need to be updated? Do you record the bases on which you lawfully process data at the moment? Thirdly, data protection policies need to be reviewed. If your organisation does not have one, you should consider creating one to show that you are taking your obligations under data protection seriously in the event that the ICO looked into your organisation at a later point. If you do have such a policy, is it up to date? How long is your data kept for? Is your personal data being retained for longer than is necessary? Fourthly, consider any commercial arrangements on data processing you have in place. In these arrangements, are you the data controller or the data processor? How is the two-way obligation and on responsibilities going to affect you? You need to check that your agreements will remain fit for purpose once liability can fall on both a data controller and a data processor. Fifthly, consider your internal systems. Are you currently in a position to notify the ICO of any personal data breaches within 72 hours? Do you need to create an action plan? Do you need to create global templates that you can use in the event of a breach? And finally, organisations should consider their insurance policies. Given the potential for greater fines under the regulation, is your current policy adequate to specifically cover the risk of a fine from the ICO for data protection breaches under the regulation? On this slide, which will be sent to you after the presentation, we have set out some links which we think will be useful for you in helping getting your business ready for the regulation. The ICO guide sets out the 12 steps that organisations should be considering now in order to prepare for the 25th of May, and the ICO homepage is always a useful first point of call for any data protection obligations. In the third bullet point, we give an overview of the GDPR, the regulation from the ICO, and the Article 29 Working Party, which Louise mentioned earlier, has set out guidance, and that is there as well.
So that brings us to the end